Welcome everybody to today's webinar on the topic of My Death, My Decision, My Donation. We have a very educational webinar for you today and fantastic speakers for you. And before I turn it to our moderator to introduce our speakers, just a couple of housekeeping items. First of all, if you are the first time participating in this webinar and would like to pose questions to the speakers, you will need to do so electronically. We do record this webinar, so we will not be opening up the lines. All you need to do is click on that blue icon on the bottom left-hand corner and on that chat icon, and go ahead and just type in your question, and we will be able to pose it at the end to the speakers. Also coming up on November 28th is our next transplant-focused webinar, and this is on the topic of navigating transplant outcomes, what transplant centers need to know. Registration is open for that. And then following that on November 30th is our third innovation webinar for this year, and it's on the topic of can nanotechnology and vitrification change the face of organ transplantation. This is a super fascinating topic, and we're excited to be able to share this with you. For today's webinar, we are offering 1 CEPC credit and also 1.2 nursing contact hours courtesy of Iowa Donor Network. Now for continuing education credits, everybody who's listening is entitled to claim continuing education credits. All you need to do is complete the evaluation process, and then you'll gain your certificate that will be automatically sent to you via email. So whoever registered for this webinar will receive the evaluation email. Some of you are listening in groups, and if you're listening in a group, whoever organized the group will have to forward that email to everybody in the room. So please make sure you note everybody who's attending the webinar so that you can forward that evaluation email to them. Also for you who are sitting in a group, please make sure to follow up with the person who registered on your group's behalf if you have not received the evaluation email. If you have any troubles, obviously feel free to contact us at the Alliance. At this point, I'd like to introduce Caroline Gordon. Caroline is one of our Get Connected webinar faculty members, and she kindly organized this webinar for today. And she's a Family Services Coordinator at Legacy of Life Hawaii. And so I will turn it to Caroline to introduce our speakers. Thank you, Caroline.
Hello, Haiti, and aloha, everyone. I hope you're having a wonderful morning or afternoon, and thank you for being with us on what I'm sure is going to be a very enlightening webinar. We have 2 speakers today, Sara Oland, who is an LMSW, Senior Director of Hospital and Family Services at Midwest Transplant Network. Sara's been working with donor families and hospitals at MTM since 2002. She brought with her 10 years of experience as a critical care social worker and hospital director. She has a master's degree in social work from the University of Kansas and was named the National Social Work Leader of the Year in 2001. As part of the MTN leadership team, she is responsible for oversight of stakeholder strategies and engagement through hospital services, directing MTN organ authorization, and supporting donor family aftercare. She feels incredibly lucky to spend her days supporting the staff who are out there improving the lives and experiences of others through compassionate family and hospital care. We also have as a speaker Sara Pace-Jones, who is the Vice President of Development and Referral Services at Donor Network of Arizona. Sara is the Vice President responsible for overseeing community outreach at the Donate Life Arizona Donor Registry, the Hospital Donor Program Development Education, Public Relations, Public Affairs, and the organization's Referral Center. She has worked in donation for over 20 years and has served as principal investigator and co-principal on several federally funded grants, focusing on the impact of various community-based interventions to improve organ donation attitudes and donor registration rates. Sara has also served as a committee member and leadership for a number of national initiatives, including faculty co-chair for the National Learning Congress of the Organ and Tissue Donation Community of Practice and chair of the board of Donate Life America. And today we also have a special guest, an incredible resource, Alex Glazier, who is not only an attorney but is the CEO of New England Donor Services, which encompasses 2 OPOs, Life Choice and the New England Organ Bank. So let's get started with our first speaker. Take it away, Sara.
Great. Thank you so much, Carol Ann. I really appreciate it. And I'm excited to be here with you today. I'm actually at a meeting in St. Louis, so not even home in Arizona, but shout out to the group in Arizona that I know is listening. I'm excited to bring this topic to you today because I think it's something that impacts us all in our day-to-day work and how we go about it, and how we prepare for situations when the family disagrees with their loved one's decision, and ensuing things that can happen from there are really important. When we talk about this in Arizona, we really talk about it in terms of our work. Most of our work is holding donor families and donors' wishes in the palm of both of our hands together. And when we are unable to, when the family disagrees with their loved one's decision, we have to work with them separately and try to bring the family together to support their loved one's wishes. And sometimes that's not important. That is not possible. So that's really what we're going to talk about today. Is we know that's incredibly difficult for families, for hospitals, as well as for our staff who are working out in the field, and even those of us who are leaders for our organizations. Those situations are very trying. So I'm going to take you through a situation that happened in Arizona, how we approached it, and some of the things that we've done in follow-up in hopes that it can help you in your work as well. So very specifically, I'm going to talk about protecting a person's decision to donate. This presentation was done originally for our symposium at Donor Network of Arizona in conjunction with the chief nursing officer of the hospital where this occurred. Just very briefly, though, to give some foundation, I think most of the people that we're talking to understand this, but just to give us some foundation about the Uniform Anatomical Gift Act, one of the primary things the UAGA, or Uniform Anatomical Gift Act, does is that it promotes autonomy and gives the donor the right to decide for themselves what they would like to happen, what they would like regarding donation. It also allows family and others to act when a donor has not. So if a person has not made a decision to be a donor, then the Uniform Anatomical Gift Act comes into play saying who can say yes to donation or who can approve of an anatomical gift. But if the person made a decision either to be a donor or not to be a donor, that is what takes primary importance in terms of legality and in terms of how we operate. It's important to note, and we always note this with our hospital partners, families do not always agree about many things, and they do not always agree about the donation decision made by their loved one, and that's what we're going to focus on here today. First person authorization, which falls within the Uniform Anatomical Gift Act, really has been the prevailing law of the land. Before the advent of registries in the early 2000s, we didn't see a lot of disputes. There really wasn't a good way for us to tell a person was registered. And so even though this has been the prevailing legality or law that we follow in the UAGA, it hasn't always been acted on, and I think that that's caused some confusion over time as we've moved towards registry and as the Uniform Anatomical Gift Act has been strengthened regarding a first person's right to authorize donation for themselves. One of the things we get asked a lot when we present this to our hospital partners and talk about this even in the public is people ask, can an anatomical gift be modified? And it's important to note that an anatomical gift made by an individual can be modified, but only by the donor. And no one other than the donor can change that decision, either to be a donor or if they've documented their decision not to be a donor. We have many ways to register to be a donor in Arizona, both through the donor registry that's available in a number of ways, through the driver's license. People can also indicate their donation decision in wills, in advance directive, and per Arizona law and the Uniform Anatomical Gift Act across the country, that is, when a person executes that, it is presumed to be valid. So let's go into a case review of our specific case in Arizona. I'm just going to start on day one and take you through the progression. I think many of you will probably be surprised how long this case went on and indeed how long the patient was able to be maintained for the purposes of donation. So on day one, a female presented to one of our acute care hospitals with brain lesions. She was alert and oriented on arrival to the hospital, and the family was there at her side, expecting her to receive treatment and for everything to be okay. On day 7, so she'd been in the hospital for 7 days receiving treatment and the hospital communicating about her condition, her mental status abruptly deteriorated, and she herniated during a head CT. At that point in time, the patient met clinical triggers for donation and was referred to Donor Network of Arizona. We also check the registry, as we always do when a patient is referred, and the patient was in the donor registry and was a registered donor. On day 8, the patient was declared brain dead. The physician mentioned donation in the context of the patient's status pretty early on, which I think many of you know cannot be good timing for the family, as they're still looking for guidance from the hospital on what they're doing to treat their patient and to save their lives. For donation to be brought up in the context of that can sometimes provide difficulty for the family. In this case, that doesn't always happen, but in this case, the family immediately became suspicious of the hospital as well as the donation decision, and contacted their lawyer. And a lawyer actually showed up at the hospital, in this case in the middle of the night. During this time, the hospital was doing everything they could to provide care to this family and help them understand what had happened. Obviously, this is a 36-year-old young woman who walked into the hospital and was alert, and for something to have happened so devastating, the family was having a very hard time wrapping their mind around that. So immediately as the family got an attorney involved and were questioning her registry status, we went into our family objection protocol. So we have a very specific process we follow at Donor Network of Arizona when a family objects to donation. First of all, if it's an MVD registration, we will verify registry status via MVD documentation. We are lucky to be able to get the actual signature with a person checking the box at the Motor Vehicle Division Monday through Friday, 8 to 5, so not at all hours, but we are able to get it in order to help families see that their loved one made the decision to be a donor. We also initiated our family objection conference call, and that is a process whereby we bring leadership at Donor Network of Arizona together with our staff who are on site at the hospital to have a conversation about what is happening, to explore other areas that we can go into related to family conversation, to make sure we're supporting the hospital and that we have good communication channels with the hospital, and also to ensure we are supporting our staff. We also, in our protocol at the time that this happened, slow the process down. So think about things that we can do to slow down and allow the family time to understand their loved one's decision. There's an asterisk next to this because following this case in our debriefing, we changed some things related to that. Additionally, we alert leadership at the hospital as well as legal counsel. This doesn't get instituted the first time a family brings up an objection to donation, because many times we can work through them on site. But when a family feels so strongly about it that they bring in legal counsel, that's something that we would initiate this immediately. So on day 10, the hospital ordered an ethics consult in order to bring some peace to the family. They also had another physician examine and declare the patient dead because the family was not believing that the patient was brain dead and also not believing that she had registered to be a donor. The family at that point in time said they wanted to transfer the patient to another facility, thinking that maybe they could get care at a different facility in a different way, and the hospital gave the family a day to either come to terms or to do that before turning the case over. So even though the patient was brain dead at this point in time, they had not turned over care of the patient to Donor Network of Arizona. They continued to support the patient as well as look for many ways to support the family. So at Donor Network of Arizona, some of the things we were doing in conjunction with the hospital were continuing conference calls, having leadership on site at the hospital, hospital development on site, and offering additional donor family and advocate support. Sometimes we find it's good to change the staff who are working with families in instances where there is mistrust that perhaps someone else could create a working relationship or a relationship with a family that would help in these instances. We also began developing a plan in case of media exposure. So we wanted to make sure that we were thinking about what would happen if this case hit the media, how would we respond, and what would our process be. One of the things we did in this case, because we had not had a family objection go public within the media, was we contacted our friends at Lifeline of Ohio because they had done a presentation about a year ago on just such a case where it had gone to the media. And we had a conference call with them, our community team along with their community team, talking about their decision making and what they did, because we really wanted to be prepared for that. On day 11, the family was not able to find someone to take over care of the patient, and the hospital turned over care to Donor Network of Arizona, and we started the donor management and organ allocation process. We also continued to speak to the family. They were not barring us from speaking with them, but they were in complete denial, saying that she had not registered to be a donor and that they did not believe that she was dead. On day 12, things really took a turn when the family members, some of the family members, began making multiple statements threatening staff if we proceeded with donation or if the removal of life-sustaining support was to occur. Due to those threats, hospital leadership followed their policy for such things and trespassed the family from the hospital. So basically they said the family were no longer allowed on the premises of the hospital unless they were seeking medical care. That's something also that we hadn't really worked through at Donor Network of Arizona, so we really followed the hospital lead because they had quite a bit of experience dealing with situations where a family makes threats or provided something that was concerning to the hospital staff safety. So we really followed their lead on that. Some of the things that we did beginning at this point in time was we were a part of hospital twice daily conference calls. Once they trespassed the family, they were on high alert and held leadership conference calls twice a day to talk about what was going on and the process. And we participated in those calls. We also allowed staff not comfortable with the situation to excuse themselves. Having been the first time that we dealt with something like that, we felt like it was important to give our staff the ability to say, I'm not comfortable with this. We also began company-wide communication, communicating about this to all of our staff because things had begun to, we had had a couple of contacts from the media and we wanted to make sure our staff understood why we were making the decisions we were doing and how we were proceeding. Additionally, we had leadership on site at the hospital both on day shift and on night shift to support our staff. On day 14, early in the morning, the family requested and received a temporary restraining order from the criminal courts preventing organ recovery or removal from life support. So they had switched attorneys at this point in time and through a family contact went through criminal court and got this temporary restraining order and simply brought it to the hospital and had it delivered to the unit. That was something that we hadn't expected and had no idea, both us and the hospital, how to proceed based on that, particularly in the middle of the night. And so as we worked through the legal process, we continued ongoing conference calls, having people on site, and working within the court system to figure out what exactly this meant, being that the patient was deceased and was legally declared brain dead. So because the patient was declared brain dead, the court system fairly quickly identified that certainly didn't belong in criminal court and transferred the case to probate court, where we spent days 17 through 20 working through the probate court system. There was on day 20 a court case including testimony by DNA, a declaring physician, the donor's husband, and 2 out-of-state physicians who were known opponents of brain death. So these 2 physicians did not attend, they never saw the patient, and they did not attend the hearing. They were brought in over conference call to testify. They had received part of the medical record from the family, and they were using that as a basis for their testimony to refute brain death in this case. Surprisingly, and maybe not surprisingly, know that a probate judge is not going to have a background in this. The judge ruled that there was not clear and convincing evidence of death and gave the family time to find another facility to transfer the patient to. So based on the testimony of these other two doctors, even though we had doctors who had examined the patient, the judge or commissioner in this case said that there was not clear and convincing evidence on this case. So at that point in time, we had Donor Network of Arizona had nothing to do but to transfer the care of the patient back to the hospital because the patient had been found to possibly not be dead by this judge. The hospital during this time began to feed the patient because that was part of the court order through a feeding tube, and brought in a consultant from outside of the hospital system to confirm brain death declaration. One of the things the judge did that is not here on my slide is that she said that the family had a limited time. They did not have limitless time to transfer the patient. So they had limited time to transfer the patient to another hospital, and they were not able to. And so she said at the end of 3 days, at the end of a long weekend essentially, if they did not find a place to transfer, then the case could come back before her court. Media interest continued at this point in time, and picketing began outside of the hospital. So on day 24 to 25, the family had not been able to find another facility to accept the patient because the patient had been declared dead, and in fact was dead at this point in time, declared by 3 physicians. So the hospital DNA filed to go before the judge again, and she granted an emergency hearing. Again, we repeated testimony both from the expert as well as DNA. At that point, the judge vacated the prior orders and ordered that the hospital, this was specific in her order, hospital and DNA proceed with all the steps necessary to carry out the anatomical gift made by the donor and as permitted by the Uniform Anatomical Gift Act. At that point in time, the family arranged for, or the hospital arranged for the family to visit to say goodbye, and there was very heavy hospital security in place as well as leadership on site at the hospital. So case outcome, liver and kidneys were recovered and transplanted in this case. During the duration of this case, the heart had originally been placed, but we lost that placement in the interim time period, and the heart was deemed no longer suitable for transplantation. We arranged with hospital security and transportation contractor for secure arrival of recovery teams, a little bit different than we generally do. The vans that arrive to hospitals with our recovery team typically are labeled with the Donate Life logo, and in this case we brought them in with none of that. It was really important to provide closure to the hospital in this case, so we held moments of silence both in the ICU as well as in the OR, openly acknowledging the difficulties in this event, and hospital staff from throughout both of the units caring for this patient participated. So what worked in this case? We had very clear intention to follow through on first-person authorization and to honor the gift that an individual gives. We had great collaboration with this hospital and a well-established relationship up to the highest levels of senior leadership at Donor Network of Arizona and the hospital, and that made a lot of difference. And ongoing and intense communication in the hospital and throughout Donor Network of Arizona. We sent out daily updates to our staff so that they could answer questions that were coming their way, and so that they understood the decision-making that we were making. Some improvement opportunities. As I mentioned earlier, we slowed this case way down, thinking that time could heal things because we felt like that would. In fact, the time made things worse in this instance, and so on all future cases, we decided that we would continue donor management and allocation as with any other donor case, continuing to work at the pace that we always do. Obviously, taking the time to have conference calls and ensuring at every step that we believe we're moving in the right direction, but continuing that process. The fact that we slowed this case down, we felt meant that we lost organs, and the case got significantly more difficult. We knew we needed to be more prepared for a legal response and have a clearer path for the court system to follow because they didn't understand. They had not really had brain death or donation before them either. So very quickly, that judicial follow-up, Haiti, after reviewing this presentation, asked me to give an idea of what that might look like. So if a patient's been declared dead, in Arizona that would fall within the probate court for most issues. And it was really important that we learned work with our attorneys who work with us at Donor Network of Arizona how the probate court system worked, and that we be able to go in, meet with them, understand how they work, and explain to them what donation is, how donation works, and what the role of the Uniform Anatomical Gift Act is. We also knew we needed to identify 24/7 contact, which is available, but you just have to ask the right questions and talk about why that might be so important to have 24/7 access to the legal system. And that pathway, just like developing a hospital or developing relationships in medical examiners' offices, et cetera, really was just a pathway. We kept connecting to other areas within the court system that we identified could use some explanation and understanding. And then we put the materials in the way they like them, which is binders, and provided a thorough resource for them should something come before the court. And followed through then with education. There are judicial education days that are held in Arizona. I'm sure that happens in most, if not all, areas of the country, and we were able to get on the program for their judicial education. People always ask what the impact was on donation. There was no noticeable impact on donor registrations that we saw, and the case got quite a bit of media exposure at Donor Network of Arizona. There was no mention of this in our family conversations throughout this time period, and the media interest dissipated pretty quickly. We held a staff debriefing. We held multiple staff debriefings throughout this and brought in a professional crisis counselor for our staff, and our staff appreciated our concern for their safety as well as our clear following of upholding the patient's wishes. Interestingly enough, we did have an update with this family, and earlier this year, a member of this family died and was declared brain dead. It was very sad, certainly for this family who had experienced such a devastating loss just a few months prior. But because the patient was brain dead, the patient was not registered, but we felt like we had an obligation to have a conversation with this family because donation was a possibility. And so our advocate staff proceeded to meet with the family, and the family considered donation. They ultimately declined donation, thinking that it would not have been this person's wish to be a donor, but they had a respectful conversation with us and truly took some time to consider what donation might mean in this case. And so that's just a little bit of follow-up. Thank you very much.
Thank you, Sara. So Sara, Oland, back to you.
Sara, are you muted?
Of course, that's exactly what I was. I was just saying thank you to Sara for sharing that case. It was very similar in terms of the takeaways that we were able to get from our case, but our case was a little bit different. And I'm very honored to be able to share it with you because we did learn a tremendous amount from this family and this experience. And I've titled the case Faith and Medical Facts, as that ultimately really is what everything came down to for us. Just a quick orientation to Midwest Transplant Network. We serve the state of Kansas and about the western two-thirds of Missouri. You can see our main office is in Kansas City, and we have 3 satellite offices. And we facilitate donation in about 230 hospitals with a population of about 5.3 million. And each year we're honored to have about 220 organ donors and 1,200 tissue donors in our DSA. And I'm going to tell you a little bit about one of those families. It was early on a Sunday morning, about 2 o'clock in the morning, and a 19-year-old young woman was brought to the emergency department of one of our trauma centers with a gunshot wound to the head, and she'd coded en route to the hospital, had an unknown downtime. A timely referral was made to Midwest Transplant Network, and the patient really had multiple reflexes, and the plan was for continued treatment. The patient was found in the donor registry. We received an update around 1400, so this would be 12 hours after admission, that the patient had had a classic herniation episode, and neurosurgery and trauma were on their way in to assess the patient, but the nurse could not elicit any reflexes. So our family services coordinator arrived on site and had a great huddle with both the trauma and neurosurgery team And a plan was made to do brain death testing the following morning. Her parents were her legal next of kin, and they were calm and quiet at the bedside and appropriately in disbelief. And the physicians really felt that they needed a little more time to come to terms with what had happened. So Monday morning we respond on site and we learn a little bit more about the family. The patient's mother is very quiet and calm at the bedside. The patient's father and grandfather are pastors. One of her siblings is out of the country, and another sibling is there at the hospital. Brain death was ultimately pronounced at 1700, around 1700. The parents and the family were praying and singing both inside and outside the room. The family asked the physician if the patient could be left on the ventilator till her sibling arrived the next evening, so that would be Tuesday evening. And the physician agreed to that. This is one of the physicians who likes to keep things very separate. So the physician went in and did the brain death pronouncement, and then we were going to go in and talk with the family after that. The patient did have a brief code and stabilized, which caused some additional family distress. But we did begin donor management at that time. And our family services coordinator first attempted then to meet with the family about 1900, introduced themselves, said, we're available, we're going to come back and check on you when you're ready. They were still highly emotional. There was a huge amount of family. Met again with them at 21:30. The family requested to go get some food. They hadn't eaten since she'd been admitted. Checked back with them at 23:45. The parents had left to go shower. And then they returned to the hospital at 2 in the morning. And when we asked to meet with them, the family said, we're not ready to talk about anything. We want to pray tonight and meet in the morning. And besides, you're kind of being pushy. We don't want to meet. We just need to focus on praying for her through the night. So we respected that. And then Tuesday came. So on Tuesday, there was a lot of concern that the family really had yet to be informed that donation was what was going to be happening. The ICU director at that point, our administrator on call were pulled in. And then the nurses were reporting that the mother was really not accepting of the brain death declaration. They had a lot of questions. They didn't believe in the brain death. So the trauma physician agreed to meet with the family and review all the testing and reinforce brain death. Again, this physician likes to do things very separately, so he did that on his own. We were not present for the conversation. Again, he wanted to keep things separate. The physician did offer the family an EEG or a CBF, and the family said they would let them know if this was something that they felt they needed. The family also asked the physician if they could not speak with a social worker or anyone about next steps until the patient's sibling got there about 2300 that night. And he said, oh, of course, that's just fine. So the patient's sibling arrived at 2300 and was able to spend some time with the patients. And so now we're actually in the early morning hours of Wednesday. And at that point, the ICU charge nurse, the bedside nurse, and the family services coordinator met with the parents, informed them of their daughter's first-person donor registry. And the parents actually expressed support of donation. In fact, their entire family signed up to be donors after a grandparent had received a transplant. We began the informed disclosure process and shared some of the time frames. And the family started asking some very pointed questions, and their demeanor started to change. They said, well, who decides when the ventilator is removed? We explained that process, and they at that point shared the belief that the patient was going to wake up because she was in the hands of God. And they were getting very emotional and a little bit frustrated. So we decided to give them some time and said that we would come back and do our medical social interview a little bit later in the day because this was the wee hours in the morning. So they wanted to get some sleep. That afternoon, the parents ended up calling the chief nursing officer and stating that they do not want to have the ventilator withdrawn and that they are going to need several days for their miracle to happen. And then at that point they requested the EEG and CDF that the physician had offered the day before. We continued donor management at that point, got the echo. Her PSR was decreasing. We were having to give blood. She was not the most stable with having had a gunshot wound to the head. So at this point then the plan was made to reconvene on Thursday morning at 9 o'clock to review the EEG and the CBF results. So on Thursday, the trauma surgeon, this is kind of when everybody got together, the trauma surgeon, ICU director, hospital leadership, risk management, NTN got together and met with the family. The trauma physician at that point reviewed the CBS and the EEG were consistent with brain death. The family then wanted a second opinion, so a neurologist came by and gave a second opinion. The family at that point shared that they were not in denial and they weren't crazy, but they believed that God was going to resurrect their daughter in His time, and they requested the policy or the law stating that they didn't have the authority to remove the ventilator, that the decision was shared with the family. At that point, MTN and the hospital had gotten together and said, we are going to remove the ventilator by the end of the day. And at that point, the family said that they had consulted legal counsel. And so MTN and the hospital's legal counsel were now activated and collaborating. And at that point, the hospital informed us that they were really hesitant to move forward with donation without family agreement with the pending legal issues. So the patient was not expedited. We didn't move forward with donation. The patient was continuing to have some instability, and in light of all of that, we stopped allocation. We didn't even start allocation because we weren't really sure what was going to happen with the legal action. So that was late Thursday evening. On Friday, we had another morning meeting, and the parents shared with us that they were excited because they could feel this patient starting to transition back into her body. And the family presented a petition to the court, a copy of the petition that their attorney was presenting to the court, requesting their daughter remain on the ventilator for 30 days. So MTN was not named in that petition. It was the family and the hospital, which I think is probably a fairly likely scenario for other OPOs to experience if things go to court. We weren't named specifically in it. It wasn't the donation necessarily that they were objecting to, although they felt donation was being pushed as a reason to remove the ventilator. They viewed the hospital as the ones who had the control of keeping their daughter on the ventilator. So at 3:30 on Friday, the hospital attorney and the family attorney met with the judge who scheduled a hearing for Monday morning. At that point, our corporate clinical officer was at the hospital, and we were all huddling. And a plan was made for the COO of the hospital, who had been working with the family, and myself to meet as the director of the Family Services Department, to meet with the parents. But the parents refused to meet with anybody on Friday. They felt that they were assured by their attorney that their daughter would be supported through Monday, and they really didn't want to meet with anybody on Friday, but they were willing to meet with us on Saturday. So Saturday came, and the COO and myself were able to meet with the family. This was a very bright, well-educated family, and we were able to sit down and we were able to agree that the hospital and Midwest Transplant Network felt the facts of the situation, the medical facts reveal that the patient had died, and the family was able to validate that this is what they'd been told and this is what they understood that we believed, but they believed that their God was a higher power than medicine, and they had received a vision from God that said He would raise their daughter up as an example to the nation and she would come back alive. And they expressed that, this may seem crazy to non-believers or medical professionals, but in their world view, God was more important than medicine, and that they were going to need to follow the vision that they had received from God and not necessarily act on the medical facts that the rest of us understood to be true. So we had really clear communication and respectful communication at that point from the parents. At that point, the hospital was still not supportive of moving forward with donation until the court issues were resolved. MTN at that point attempted to step back from the situation and turn the patient back over to the hospital. However, no physicians at the hospital would agree to take over care for the patient. So MTN COO and the hospital CEO met, had some really good discussions on a Saturday and Sunday. They agreed to have an ethics consult done, and the COO was able to collaborate with the ethics committee chair on Sunday, and they agreed to have an emergency meeting at 7 a.m. Monday morning. MTN at that point agreed to stay involved until Monday to work through some of the initial court hearing, which was set for Monday morning as well. So there was a 7 o'clock hospital ethics committee meeting on Monday, And the resulting recommendation from the Ethics Committee was to support the patient's donor designation and move forward with donation if the court's, pending the court's decision, but that ethically they would support moving forward with that. That really helped the hospital to feel comfortable honoring the first person authorization. While this was, as soon as this was over, the whole MTN leadership team with the clinical side and hospital development as well as public relations went to the hospital, and we were in a large meeting room with the whole leadership team of the hospital awaiting the court decision. The petition to keep the patient on the ventilator was denied by the courts. The parents then asked for 3 more days from the hospital, and this was denied as well. So because we had all of our leadership together, we were able to come up with a collaborative plan to meet with the parents, and the COO of the hospital and myself, again, went and met with the parents, and we had this collaborative plan to share with them that the immediate family was going to be allowed to stay with the patient, but that the extended family would need to leave by 5 p.m. We set some very clear behavioral expectations for continued bedside presence. It was a large family, and the direct family, the immediate family members were very respectful at the bedside, but some of the extended family were causing trouble in the waiting room outside of that and when they would come to visit. So we made a plan. They had 2 hours to say their goodbyes, and we actually introduced them to the security guard and said, we introduced them to security and aligned them with security, saying we know that there are a lot of emotions and you understand the expectations so that you can continue to stay with your daughter if you need help. He will be a resource for you. It was a very collaborative and a great thing I think that we did in the moment. The family continued to refuse informed disclosure, refused to participate in the medical social history, but Mom did accept a follow-up letter, so she would be open to having a follow-up letter. And we decided at that point, in addition to our organ procurement coordinator, that our corporate clinical officer, the director of organ procurement, and myself would stay on site and facilitate the case, just so that we could have our decision makers there and at the ready and able to support the staff no matter what was going to happen as we move forward with this. We did do allocation, and the parents remained at the bedside. And the OR was actually sent for the early mornings of Tuesday. And the family was stoic. At times they were grieving, sometimes loudly, lots of praying, lots of singing. And we worked with the nurses who had taken care of this family for a long time. And they were able to stay at her bedside, and they were cooperative, yet they were really angry. But their daughter was able to donate a kidney to a 58-year-old father of 2, and her kidney and pancreas to a 48-year-old woman. We had placed the liver, and during the organ recovery there were some clotting issues, and we were not able to continue to move forward with that for transplant. So we really did learn some lessons, and as difficult as it was, we have been very grateful for this learning opportunity. And some of the things we learned is sometimes saying next steps for families who are not ready for next steps is scary. And so if we say we'd like to meet with them about next steps, they then avoided meeting with us. And we kind of paced them into exhaustion, trying to be respectful. But then we reached a point where we really needed to have an informing conversation with them because we were moving forward and they didn't know. So we've learned a lot about how to set that up with families in the future and not to wait as long to have that informing conversation. We also learned that once a patient is declared, that we really should be involved in all the hospital and family meetings. We found ourselves in situations where the hospital physicians were allowing the family to delay and delay and delay, and we were not involved or really huddling at that point to come up with a collaborative plan. We did add an ethics consult onto our first person opposition algorithm to where that would be a routine part of what we would do as we were working through any of these issues in the future. And the importance of the high-level alignment with the MTN executives and the hospital executives was very helpful for us. Having the decision makers and people who can outline the plan then really helped us support the frontline staff in a very important and meaningful way, both at the hospital and the MTN staff. Again, as Sara Pace-Jones indicated, the need for daily collaboration via email or conference calls or meeting at the leadership level. This was all very important as we continue to move forward. And the critical need for debriefing with frontline staff, both hospital staff and MTN staff. There were a lot of high emotions, and through the process we were able to keep focused on the family and the patient and the staff and getting through this. When we did our debriefings, we found out some things that we didn't know, but we were able to really focus on the facts. And we felt a lot of anxiety from the hospital staff and thought that was directed at the OPO, when really they were very frustrated with their hospital physicians for not taking a stronger stance or moving things forward, and they felt that's what the family meant. So being able to debrief helped us to learn everyone's perspective about what was going on. And the need for consistency, that is a huge thing. We have learned, this case happened a couple of years ago, and we have put our opposition algorithm into place a couple of times, only one other time reaching the complete escalation to where the CEOs are talking. But working through the algorithm consistently in every single case has helped us to feel more confident in what we do and how we continue to support our families and our hospitals through this process. Going through this with this hospital has resulted in a much improved relationship with them. The way it was handled and the way we ended up collaborating together. This hospital has gone on this year to set records for the number of organ donors they've had, and actually to receive awards for their commitment to donation. And it's not just led to a better relationship with this hospital, but it has really helped us to better serve other hospitals and family throughout our DSA. So that was our story about faith and medical facts. And I think at this point we're going to turn it back over for some questions.
Thank you, Sara and Sara. Wow, I'm sure we can all relate to some of the anxieties that you must have experienced during these two cases. I just want to remind everybody this is the time that we're going to be able to pose questions to both Sara and Sara, and also we have Alex Glazier, who is an attorney as well as a CEO of an OPO, and she's also on the line to be able to help address legal types of questions that you may have. On the bottom left-hand corner, you see that little icon. Just click on that, type in your question, and Carol Ann will be able to pose that. While we do the Q&A time, I have this poll up that if you're listening in a group today, please complete this poll as to how many people are in your group. I will turn it back to Carol Ann to get us started with the questions.
Thanks, Heidi, and thank you for those wonderful presentations. The first question I have is for Alex, our attorney, who did not present but is here as a resource. Can you name top 3 things that our audience can take with them today to help them be prepared, either OPOs or hospitals, for when such a situation should occur or would occur again?
Yeah, great question, and we've already heard a couple of excellent suggestions from both the presenters of things you can do to prepare. If I were to summarize this into 3 categories, I would say, number 1, educate hospital counsel, focus specifically on your major donor hospitals, about both the UAGA and specifically the first person authorization provisions, but also brain death and the brain death law that's applicable in your state, as well as what the escalation plan is, or as another term, the algorithm that will be used when there is significant family conflict. Have an email ready to go to counsel or to the risk manager or whomever might be on call that wasn't part of training initially, that has a summary of the UAGA, pulling out particularly the first person authorization provisions and any hospital agreement provisions related to supporting first-person authorization that you may have in the agreement between the OPO and the hospital. So that's category number 1. You can do this well in advance, educate the hospital. Number 2, when you're faced with a serious conflict with a donor family and there's a registered donor, really try and parse out the issue. Is it a concern with brain death, or is it a concern with the donation, or is it both? And that really changes the legal and risk strategy as well as how you may handle the escalation. when you're managing a conflict like this. You really want to resolve the concern over brain death first and try and leave the donation issue secondary, because the law in the UAGA, as you know, and as Sara reviewed, is very clear in supporting first-person authorization. So if you can resolve that the patient has in fact died in accordance with an appropriate medical diagnosis and declaration and the law, then it really helps to address the donation component separately. So to manage the conflict, try and understand whether it's really about accepting the death or whether it's really about donation or both. And then the third category is, when you find yourself in a situation where it's escalated, of course you would confirm the brain death diagnosis was made in accordance with the law and the hospital policy, but also request a death certificate. And we have found that this actually has stopped potential run to court in several cases for our own OPOs, because lawyers and courts know exactly what a death certificate is. They don't necessarily know what a brain death note is. So having that documentation that's consistent with how the legal system views a final documentation of death has really been, I think, extraordinarily helpful, and I definitely recommend doing that, as well as, I think Sara mentioned this, getting a copy of the donor registration, the original one, if at all possible. So if you can get a copy of the licensure application with the signature, for example, we have found that very helpful. Pulling together those components quickly in a moment of when there's been full escalation and there's attorneys involved, I think can result in preventing the court hearing, which is obviously very helpful to the process, first of all, and not losing the potential opportunity to transplant all the possible organs when too much time goes by, which can definitely happen if you find yourself in court, but also the opportunity that the court might get confused or get it wrong, which is, as you've seen in these cases, a definite possibility. So those would probably be my top three.
Excellent, Alex. Thank you so much. We are getting a lot of really excellent questions. I'm going to try to group some together that go along the same line. So one question, and this is not directed to anyone in particular, any advice on situations in which the family is objecting to FPA and they are requesting discontinuation of ventilation? This goes hand in hand with another question, which is how do you or would you respond to the family that tells you that the patient did not understand what they were registering for, or had they known the process would not have registered to be a donor? So those questions seem to be hand in hand. These seem to be questions about objecting to whether or not the patient did register and not to doubt of the patient being dead.
Well, this is Alex, and I'll give a very brief answer, and then I'm sure others will have things to say as well. Maintaining the patient on ventilator support is required under the UAGA. So I think while a conflict remains and needs to be resolved in the escalation process that the hospital and the family and the OPO would participate in, it is clear under the law that the patient ought to be maintained. So ventilator support should remain in place while all of this is being resolved. And in terms of the question of not understanding the registration, I think all of us have handled questions like that in the past, and I think that it is important to note that the UAGA sets up a gift law standard. It's not an informed consent standard legally, and that we do assume that adults are competent to read and sign for all sorts of things in our country, not just anatomical gifts, and that same legal assumption applies here. So they're able to renew their license and sign for that. The assumption is that they understood sufficiently for the purposes of the law to have made the anatomical gift as well. And then I'm sure there's others that can add to that.
One of the things that we do is we also provide a copy of the UAGA to the family to help generate some discussion about legally the need to maintain the ventilator so that they understand the legal framework behind that. Our family services coordinators are very skilled at negotiation as well, and so besides education and sharing with them about gift law, we give an example usually about in a will, I could leave my fancy car to my next door neighbor and no one could do anything about it if that was what was in my will. And that donation is similar to that people make the decision to donate based on what their wish is and what the gift is that they want to give. And when they want to remove the ventilator quickly, we can sometimes do negotiations and look at how can we expedite the case in terms of the amount of resources that we put forward to move the case forward faster.
Our process is very similar.
Okay. Moving forward, we have another couple of questions that could go hand in hand. For Sara Pace-Jones, what tests were used to declare brain death? And then a secondary question from someone else, how can one obtain a death certificate while the patient is still on a ventilator?
So I'll take the first one. The test that declared brain death in this case, the patient was declared via CBF. So, a very firm. Interestingly enough, the hospital did not follow their policy initially by completing an apnea prior to CBF, which became a little sticking point in the court system, even though it wasn't required under national standards if the patient was declared via CBF, because it wasn't done the first time, and the second time complete clinical exam, apnea, as well as CBF repeated.
In terms of the death certificate, if the patient has been declared deceased, in accordance with the state law, which would be based on the brain death diagnosis, then the death certificate should be able to be filled out. I understand that it's usually hospital protocol that wouldn't happen until the death certificate is not usually filled out at that moment, but there's nothing that prohibits the hospital from doing so. And again, we've actually found that extremely helpful if you get to the stage where lawyers and courts are involved. It's not something I would suggest asking the hospital to do just, at any moment when there's a family conflict. But to the extent that you find yourself in court, having a death certificate is significantly more recognizable for the court system than a brain death note, and should be able to be obtained from the declaring physician.
We have a question for both our presenters. Who paid for the length of stay in each case post-pronouncement?
So at Donor Network of Arizona, we have case rates with our hospitals, a flat rate that is paid depending on the type of case that it is. Obviously, this case went far beyond most cases that happen, and because we took over care twice, essentially because of the court system, we paid our case rate twice to the hospital. We just felt like that was the right thing to do in that instance, but we paid our case rate.
And at Midwest Transplant Network, this was something that was discussed along the way, and in the moment that there would be some days probably carved out as the hospital was very uncomfortable. We were ready to move forward, and the hospital put a pause on that because of the legal proceedings and everything. So we paid for a lot of it, but then the hospital did carve out a few days in there where they were not allowing us to move forward.
Another question, what should be done to authenticate registrations made via an online registry?
Yeah, this is a great question. One of the processes we have here with our OPOs and our escalation process is whenever there's a family conflict, you want to make sure death is declared appropriately in accordance with the hospital policy and law, as we've already said, and also make sure and confirm that the donor registration looks correct on its face. And so that's things like, do we double check that the name is correct, the address is correct, and all those things? What's the nature of the registry objection by the family, and have we tracked that down? With a DMV registration, you might have the opportunity to get a copy of the actual registration if it was done in paper with a signature. If it was online or it was through the DLA registration, you may be able to get some information from the database with regard to when the registration was made, which is helpful, so you have an actual date and time. And in some web-based registrations, you might be able to get a digital certificate or some other authentication of that transaction that created the donor registration. It's going to depend on the registry itself.
All right. Okay. We had something for both presenters saying, excellent presentation, thank you. For both presenters, what has follow-up from the OPO, the aftercare, been like for these families post-donation?
For the Midwest Transplant Network case, I talked to the family about that during the moment in terms of what amount of follow-up they would want, and they denied wanting to be on our mailing list or receive any follow-up except for the outcome letter. The mom wanted the outcome letter, and that was all that they requested. So we have not had any other further contact from them since we mailed them the letter about the outcome.
And at Donor Network of Arizona, the family requested no follow-up at all, so they didn't want to receive any of our follow-up. That is different than most of the cases that have begun with objection. In most cases, families, by the time we get through our process, want follow-up and are in a place where they want to know that. But in this case, this family didn't want any further follow-up.
We've got two more questions. I know we're at the top of the hour. For the MTM case, was the family's pastoral staff at the hospital at all or involved in any of the conversations?
The patient's father was a pastor at the church, and so was the grandfather. So they were providing their own spiritual guidance along the way.
Thank you. And suggestions on how to navigate cases where transplant recipient families decline donation regardless of FPA.
I think that's a challenging one, and it's obviously something where donation is an individual's decision, and even a transplant recipient may not want to be a donor, which is, I think, hard for individuals to understand, but falls into that line of individuals get to choose. That being said, it is something we've looked a little bit more closely on. How are we working with our transplant centers to educate transplant recipients about the importance of donor registration and how that helps the donation system? And our hope is that we'll get to a time where it's very rare. I mean, it is fairly rare already, but that it's even more rare to see transplant recipients who deny donation.
And that's all the questions we have in the queue.
Thank you so much, Carolyn, for moderating excellent questions. And a very special thank you to Sara and Sara for sharing these cases and sharing how you navigated them and educating us to your processes. I think we have a lot that we could learn from that. And Alex, a special thank you to you for your sharing your expertise on this call and providing us with some very helpful tools on action items we can take to prepare ourselves. I actually do have one more question that just popped in the queue, and Sara, Oland, I'm not sure if this is something that you can answer quickly or if it's something that you might want to follow up with the individual by email. The question is about what does the first person authorization algorithm contain?
I am happy to share our algorithm with anyone who would like that. It basically outlines a dual track between the hospital and MTN on how we escalate and work through opposition as it continues to progress. A lot of times the initial objection is able to be overcome with education and time and support, but if it doesn't, then how we escalate that to mid-level resources, bring in the ethics committee, and then how ultimately it escalates into the CEOs talking. So I would be happy to share that.
Okay, great. Thank you so much. We are past the hour, so we will, at this point, follow up with any questions via email. Thank you all so much for your participation in this webinar. It's great to see so many great questions coming in. I wish you all a wonderful rest of the week. And for the presenters, I will be moving us back into the speaker room. Thank you all so much. Bye-bye.